Bob, and I will be covering the case brief of Clifton Jones and Cora Jones versus Star Credit Corporation. Star Credit Corporation is a financial company that was founded in 1959. This company was supposed to focus on household goods and appliances and offering low and middle income families a financial services that they could not afford that when they could not afford items up front, they were able to go into a contractual agreement with this company. Star Credit would generate revenue exceeding $10 million annually, and in 1963 they reached their highest peak in financing of durable goods. They was on their way of being one of the highest financing companies in the U.S. Their profit margins consistently hovered over 40% every year. In August 31st of 1965, Clifton Jones and Cora Jones felt that they were being taken advantage of and was being overcharged for a refrigerator that they purchased for personal use. They entered a contractual amount for $900 for the refrigerator, which in turn there were additional fees and interest that eventually totaled over $1,200. They felt that they were misled and was unaware of the amount. Once the Jones had paid $619 into the freezer, they still owed a substantial amount that they argued in their contract was very unfair. The legal issue of this was the unconscionable reasoning of this contract and the amount of what they were owed that was owed to Star Credit. The main argument for the plaintiffs was the unfair markup 300% value of the contractual price. As stated previously, the freezer appraised at originally $300. They entered the contract for $900, and the fees exceeded over $1,200 for their freezer. The defendant's argument was that the Joneses knew what they were getting themselves to. They were not misled, and everyone agreed upon the terms of them signing the contract. They knew all of the additional fees and the amount that they will be paying in the future to the company for their appliance. The court's ruling decision was that the contract was unconscionable and that Star Credit did take advantage of the company, and they ruled against Star Credit for that markup of the consumer price. It was just wanting them to protect the consumer a lot more in the court's eyes and making sure that they know that the amount that they're actually paying, and they wanted the decision to emphasize the principle of unconscionably in the consumer's contract, a notion that continued to shape the industry and regulations. Star Credit saw a decline in its customers and the negative press damage in their reputation. In the next 3 years, their consumers went down 15% overall, and industry-wise, they extended credit to low-income consumers, but consumers did not feel comfortable putting their faith back into Star Credit. Unconscionably, in which the courts have the authority, is invalid contracts were excessive, and I do agree with the court that in that economy and this economy, it all plays that exceeding those amounts, it was taking advantage of the consumer and not allowing them to pay what they could afford on their income to the company to finish out their obligation, and they felt that they were being taken advantage of in this situation.